Sorry, person at the jail, please state your name for the record.
My name is Andrew Smith.
All right, you can go ahead and have a seat.
Thank you.
All right, this is the case of the people of the state of Michigan versus Andrew Allen Smith, case number 26-1524 FD. Mr. Smith, you met with somebody from Community Corrections today and gave them some contact information. Was that information accurate?
Yes, sir.
And did you have the opportunity to meet with somebody from the defender's office today?
Yes, I did.
I have a complaint that alleges that on or about April 26, 2026, in Herring Township of Wexford County, it is alleged in count number 1 that you committed the offense of operating while intoxicated or impaired as a third or subsequent offender. That is a felony punishable by a fine of $500 to $5,000 and either 1 to 5 years in prison or probation or 30 days to 1 year in jail, at least 48 hours to be served consecutively, and 60 to 180 days of community service, rehabilitative programs, vehicle mobilization, and reimbursements for the cost of prosecution and governmental expenses. In count number 2, it's alleged that you committed the offense of open alcohol container in a vehicle. That is a misdemeanor punishable by up to 90 days in jail and or a fine of $100 and community service with substance abuse screening. Do you understand those charges and the potential penalties?
No, sir. The last I had a drunk driving in 82.
So I show that there is 1982 in the 2B District Court in Hillsdale County, and then
Yes.
in December 20th of 21 in Hawkins County, Tennessee.
Yeah, that's right. That's correct.
Okay.
I thought it was just Michigan. That's right.
No, yep. Okay. So this would be your third from across the country. So do you understand those charges?
Yes, sir.
All right. And do you understand the potential penalties?
Yes, sir.
All right. On felony complaints, you have certain rights. You have the right to remain silent. Anything you say or write can and will be used against you. You also have the right to have an attorney represent you during any questioning you consent to, and the right to stop answering questions at any time. You also have the right to be represented by an attorney at all phases throughout this process. And if you could not afford one would be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
I'll have a court-appointed attorney, please.
All right, the court will make a referral to the public defender's office for the appointment of an attorney, will enter a not guilty plea, and will set the matter for a preliminary examination. That's a hearing that's held here in the district court within 21 days. At that hearing, the prosecutor is required to prove 2 things: 1, probable cause that this crime had occurred, and 2, probable cause that you were the person who had committed the offense. If the prosecutor is not able to do that, the case would be dismissed. But if they are able to do that, you'll be bound over to stand trial in circuit court. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments and the threat that you pose to the community. Counsel, historically, I show the 82 OUIL and the 21 DUI out of Tennessee, and the praxis scores him at a risk level 2. Any comment regarding bond, Mr. Shantz?
Thank you.
Hold on, Mr. Smith, did you have a question?
Yeah, yes, my comment is I blew a .06, which was below the legal limit.
Okay, all right, Mr. Shantz.
It doesn't make it right. I just wanted to note that.
Thank you, I appreciate it.
Okay. Yeah, Mr. Smith reports that he lives in Grand Rapids. He is currently between housing at the moment. Unfortunately, his home in Tennessee burned down about 1.5 years ago. He was actually going up to Roscommon to stay with some friends when he was pulled over. He had been driving from Tennessee, and when he blew that .06, we would also highlight that he reports to me, at least, that he has never failed to appear and that he would promise to come back. He is struggling right now with the lack of home, and he is not currently employed, as far as I'm aware. We would also highlight the practices of 2, and that the time between his last OWI in Michigan is 1982 until now. We would respectfully request a personal recognizance bond, but we would be open to any conditions the court deems necessary in order to ensure his continued adherence. Thank you.
Thank you. Ms. Lawrence?
Your Honor. The defendant's PBT in this case was 0.063. The defendant did admit to mixing that alcohol with his prescription Xanax as well. Given the fact that this is a third OWI and his most recent was not too long ago in 2021, I would ask the court to impose daily alcohol testing. I would also ask the court to impose random drug testing, at least until those labs are received back. I do have some flight risk concerns given the defendant's lack of stable housing at this time, but I will leave bond up to the discretion of the court. Thank you.
In the theory of the case, at least as of it sits now, is that the combination would be the alcohol and the Xanax.
Correct.
So what brought him to the attention of law enforcement? Looks like this was in the KFC parking lot.
Yes, he actually went through the KFC drive-through and was asking the workers for directions, and they believed he was intoxicated and called law enforcement.
Okay. Mr. Smith, the residence that you were going to in Roscommon, how stable is that residence for you?
Well, it's my sister's home. And I wasn't actually sure she was there, so if able, I was gonna go back to the homeless shelter in Grand Rapids. I do not have her phone number at this time, and I was hoping that she might be there. So given this change of circumstance, I would just go back to the homeless shelter in Grand Rapids at the 223 Commerce Avenue South in Grand Rapids, floor 9503. It's a minute. It's a
223 or 225? We have 225.
Yeah, 225. I misspoke. It's a Mel Trotter Ministries, a homeless shelter. It's 225. I must have misspoke.
Okay. So were you going up to your sister's to hope to stay there, or were you going up to visit?
Visit. I have been estranged from her. So I wasn't certain that she would even be at the residence. She has a residence in Troy as well. So that was kind of a whim as far as my pursuit of driving there. So now that this has happened, I don't think it'd be a good idea to go there, regardless of what your ruling is today. I'm going to go back to the homeless shelter. There's a curfew of 7, otherwise I can just stay in my car at the Family Dollar parking lot. And because they have a curfew of 7 o'clock, and then if you're not in by 7, then you can get in by 8:30. You can get in there at 8:30 the next morning, but if they have a curfew cutoff at 7 p.m. So if I'm not there by 7 p.m.
All right, Mr. Smith, as a condition of your bond, I'm going to order that you appear as ordered, keep your contact information current, not leave the state without permission, and to commit no new crimes. I'm going to order that you not consume any alcohol, and you'll be subject to random testing and no illegal controlled substances, recreational marijuana, and you'll be subject to random testing for that as well. You also must enroll in community corrections services. I will authorize your release on a personal recognizance, which is your promise to come back to court. All right.
Yes, sir.
At some point, you're going to be released from the jail today. You're going to need to make your way over here to the courthouse, which is about 5 blocks from where you're at, and go to the community corrections office, which is on the ground floor, and get set up for your testing requirements and your other requirements. All right.
Yes, sir. I need, if I could, I'd like to call my credit union, and I know it's not a frivolous request, but that's where my funds will come from to get my vehicle out of impound. I have a credit card, but I need to move funds to the credit card. I know that it seems trivial, but I'm broke.
I don't, so that's something that I have no control over. I don't know if they'll let you do that at the jail or not.
Okay, I'll have to do it, if they'll let me, I have to do it by 4:30 when they close, otherwise I can do it tomorrow morning, but otherwise I need a place to stay. I don't know if I have the gas to get, to the homeless shelter.
Okay. Well, you can talk to corrections and they might be able to give you some ideas, okay?
Okay,
All right, thank you. Next arraignment.
thank you.
A person at the jail, please state your name for the record.
Kyle May.
This is case number 261532 FY, the People versus Kyle Thomas May. Mr. May, you met with somebody from Community Corrections today and gave them some contact information. Was that information accurate?
Correct, yes.
And did you have the opportunity to meet with somebody from the Public Defender's Office today?
Yes.
I have a complaint that alleges that on or about April 27th, 2026, in Selma Township of Wexford County, it is alleged in count number 1 that you committed the offense of controlled substances, possession of a narcotic, less than 25 grams, in particular cocaine. That is a felony punishable by up to 4 years in prison and or a fine of $25,000. In count number 2, it's alleged that you committed the offense of operating while intoxicated, under the influence of alcohol as a third or subsequent offender. That is a felony punishable by a fine of $500 to $5,000 and either 1 to 5 years in prison or probation with 30 days to 1 year in jail, and at least 48 hours to be served consecutively, 60 to 180 days of community service, rehabilitative programs, vehicle immobilization, and reimbursements for the cost of prosecution and governmental expenses. In count number 3, it's alleged that you committed the offense of open alcohol container in a vehicle. That is a misdemeanor punishable by up to 90 days in jail and or a fine of $100 in community service and substance abuse screening. Do you understand those charges and the potential penalties?
Yes, sir.
On felony complaints, you have certain rights. You have the right to remain silent. Anything you say or write can and will be used against you. You also have the right to be represented by an attorney during any questioning you consent to and the right to stop answering questions at any time. You also have the right to be represented by an attorney throughout the pendency of this case. And if you could not afford one would be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
Request a public attorney.
All right, the court will make referral to the Public Defender's Office for the appointment of an attorney, enter a not guilty plea, and will set the matter for a preliminary examination. That's a hearing that's held here in the district court within 21 days. At that hearing, the prosecutor is required to prove 2 things. 1, probable cause that the crime had occurred, and 2, probable cause that you were the person who had committed the offense. If the prosecutor is not able to do that, the case would be dismissed. But if they are able to do that, you'd be bound over to stand trial in circuit court. Prior to that preliminary examination, there'll be a probable cause conference, which is where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments and the risk of danger you pose to the public. Counsel, I show in 11, there was an operating while visibly impaired, and in 24, a high BAC. The Praxis scores him at a risk level 3. Mr. Shantz, any comment regarding bond?
Thank you, Your Honor. Mr. May lives in Grand Rapids. He's been residing in his current residence for 4 months. He rents, but he also owns a home there that he was living in previously. That he now rents out in order to make additional income in order to support his 2 children, age 7 and 9. He reports he pays about $1,200 a month in child support, and that he had just started a new job several weeks ago with Freedom Construction, where he's actually supposed to be working today, and he is very concerned if he's unable to post bond that he will lose this job and he will fall behind on his child support payment. He's concerned about this. Not only is he concerned about this financial snowball effect, but also I believe he's concerned about the snowballing effect of his own struggles with substances as well. I think he understands the seriousness of what he faces. But I say that to say I don't believe he is a flight risk based on the fact that he does have 2 children enrolled in school in Michigan. I don't believe he has any plans to abandon them or his property. We understand that, you know, he expressed desire to do both drug and alcohol testing. I think he understands that he has a problem when he relapsed.
Is the relapse with alcohol or drugs or both?
Alcohol.
Okay.
Yeah. I think he understands the seriousness with which he faces himself now, and that he's found himself in a good place with alcohol before this, after the previous OWI in 24. He's expressed that he had found himself in a good spot, and then now he has obviously found himself here. So he is open to that drug and alcohol testing in order to create more structure for himself. We would respectfully request a PR bond, but we would open to any conditions, including tether, if that would appease the court's concerns about his appearance. Thank you.
Thank you. Ms. Lawrence?
There was a PBT done in this case that came back at 2020 through 9. There was also multiple beer and liquor bottles found in the vehicle, as well as cocaine seen in plain view on the center console of the vehicle. The defendant did tell law enforcement officers that his blood would probably come back positive for cocaine. Given that, I would ask for random drug testing, as well as the fact that this is a OWI 3rd. I would ask for daily alcohol testing. I do think because this is now his 2nd OWI in a pretty short period of time, that he is a risk to public safety. I do think some type of monetary bond would be appropriate in this case, but I will leave it to the discretion of the court. Thank you.
And what brought him to law enforcement's attention?
This was actually a dispatch received from Kent County of a potential drunk driver who was suicidal.
Mr. Thomas, I'm sorry, Mr. May, I apologize. If I were to release you, do you have a way to get back and forth to court?
Yeah, yep. I have family that live nearby that will arrange that for me. In Grand Rapids, that is.
Okay. And the only reason I ask is because your lien shows that you should have been on probation. Were you on probation during this, or had you been released early?
I was discharged early back in January. So.
Okay. All right, as a condition of your bond, sir, you are to appear as ordered, keep your contact information current, not leave the state without permission, and to commit no new crimes. You are not to consume any alcohol, and you'll be on daily testing. no illegal controlled substances, including recreational marijuana, and you'll be subject to random testing for that. I believe that is appropriate, given the defendant indicating to law enforcement that he would probably have cocaine in his system, and he blew a .139. I believe the testing requirements are appropriate. In regards to a flight risk, I don't necessarily find Mr. May as a flight risk. So I believe any concerns that I have can be dealt with those testing requirements. And Mr. May, I'm going to release you on your own personal recognizance, which is your promise to come back to court. So at some point today, you're going to be released from jail. Before you're released, you'll have your next court date. Make sure you keep track of that. And then you'll need to come over here to Community Corrections, which is located at the courthouse on the ground floor, and get signed up for your testing requirements.
Okay.
All right.
Yes, sir. Yep.
Next arraignment. The person at the jail, please state your name for the record.
Devin Bell.
All right, these are case numbers 261511FY and 254028ST. Both are captioned "The People of the State of Michigan versus Devin Allen Bell." Mr. Bell, you met with somebody from Community Corrections today and gave them some contact information. Was that information accurate?
Yes, sir.
And did you have the opportunity to meet with somebody from the defender's office today?
Yes, sir.
In the older file, the 25 file, I have a complaint that alleges that on or about August 26, 2025, in the city of Cadillac, it's alleged in count number 1 that you committed the offense of fail to stop after a collision. That is a misdemeanor punishable by up to 90 days in jail and or a fine of $100. In the 26 file, I have a complaint that alleges that on or about April 24th, 2026, in Cedar Creek Township of Wexford County, it is alleged in count number 1 that you committed the offense of controlled substance possession of methamphetamine. That is a felony punishable by up to 10 years in prison and or a fine of $15,000. The prosecution is also elected to charge you as a second or subsequent offender, meaning that you have at least one prior drug conviction in your past. That makes that 10-year felony punishable by up to 20 years, and the $15,000 punishable by up to $30,000. In count number 2, it's alleged that you committed the offense of operating while intoxicated under the influence of a controlled substance. That is a misdemeanor punishable by up to 93 days in jail and or a fine of $100 to $500, rehabilitative services, reimbursements for the cost of prosecution and governmental expenses, and or 360 hours of community service. The people have also charged you as a habitual offender 4th, meaning that you have at least 3 either attempted or completed felonies in your past. That would make that 10-year felony a life offense. That is charged in the alternative from the second or subsequent offender. So if you were to go to trial, they would only be able to try you on both, or I'm sorry, on one of those enhancements, not both. Do you understand that?
Yes, Your Honor.
On felony complaints, you have certain rights. You have the right to remain silent. Anything you say or write can and will be used against you. You also have the right to be represented by an attorney during any questioning you consent to, and the right to stop answering questions. You also have the right to be represented by an attorney at all phases throughout this process. And if you could not afford one would be appointed to represent you at public expense, but you may be required to repay a portion of that expense. In the felony file today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
I'll request one. Your Honor,
Alright.
request.
And in the misdemeanor file, do you wish to represent yourself or request the appointment of an attorney?
I just request one for that too, I think.
All right, the court will make a referral to the public defender's office in both files. Let me get caught up on my notes here. We'll enter a not guilty plea in each, and we'll set the misdemeanor for a pretrial and the felony for a preliminary examination. That's a hearing that's held here in the district court within 21 days. At that hearing, the prosecutor will be required to prove two things: one, probable cause that the crime had occurred, and two, probable cause that you were the person who had committed the offense. If the prosecutor is not able to do that, the case will be dismissed. But if they are able to, you'd be ordered to stand trial in circuit court.
Yes, sir.
You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Historically, counsel, I show in 09 a UDAA, along with a B&E with intent, another B&E with intent. In 10, there was an aggravated assault, 11, an assault and battery, 19, receiving, concealing less than 200, 22, possession of meth, 22, resist and obstruct, and an attempted disarm police officer. The praxis scores him at a risk level 3. Any comment regarding bond, Mr. Shantz?
Thank you, Your Honor. Just to clarify, are there separate bonds on both files or are they just one bond?
We would set a bond for each file,
Do you prefer me to start with one or the other?
however you want to handle it.
Okay, well, on the 2005 failure to stop, we would respectfully request a personal recognizance bond. And then moving toward the possession of meth and the OU ID, including the second subsequent, they have for several things. I think one, he expressed to me that, and I want to, that this, he understands the seriousness that his relapse has created for himself. I think, I think Devin really understands what a grip this addiction has on him. He explained to me that he had been 3 years sober before his most recent relapse. And I know some of that was time behind bars, but did create a structure with which he was able to be sober. And he was actually he was not working for a while after his release, and he was sober. He was taking care of his young children. He has 2 young children, one 18 months old and one is 10. They both go to school here in Cadillac. His wife and his kids and him all live together here in Cadillac. They've been living here for about 10 years. But he had been at home taking care of them and had given them that purpose and that structure. And then he thought he was in a position where going back to work, where he is currently employed with Callahan Supply Concrete. He thought maybe going back to work would be good. In addition to, he felt like he was in a place where he could leave the house and then go out in public and work again. And then he explained to me how that lack of structure, you would think that work would create the structure, but actually in his job, moving around quite a bit, there really isn't as much structure as maybe he might need. And it led to this relapse. We understand, I think he understands the seriousness, and we would also highlight that he's never failed to appear in the past. I think he intends to, and I know he intends to face these charges. We do not believe, therefore, that he has any sort of flight risk. And he also expressed to me that he would be open to drug testing and alcohol testing, not only because it would appease the court in order to get him out so he could see his kids, but just to create that structure that allowed him to be sober for 3 years before this. We would respectfully therefore request a PR bond, or in the alternative, a low monetary bond, so that he would be able to bond out in order to take care of his children. Thank you.
Thank you, Ms. Lawrence.
Thank you, Your Honor. This is a case where law enforcement officers believe he was under the influence of methamphetamine while he was driving. Standard field sobriety tests were done, in which he did poorly on. On top of that, his behavior was very erratic. He was making statements that didn't make a whole lot of sense to officers. We are waiting on that blood draw at this time. So until then, I would ask the court to impose random drug and alcohol testing until we receive those results. There was also a methamphetamine pipe with residue on it found in the vehicle, as well as a candy wrapper containing a small amount of methamphetamine in it as well. Given the seriousness of these felonies, I would ask the court to impose a monetary bond. I would ask for a $25,000 cash surety bond in the felony file, and as for the misdemeanor file, I would leave that up to the discretion of the court. Thank you.
Mr. Shantz, had Mr. Bell completed parole?
I believe he had, yes, as we expressed.
The felony file, based on what's presented today, I do find the defendant presents as a threat and flight risk in that it's alleged that he was operating under the influence of a controlled substance. He was found with controlled substance. He has a history of controlled substance use. So I do believe he poses a threat, and near as I can tell from from the probable cause affidavit, there may have been at least allegations, although not charged, of him potentially trying to flee from the police. So bond will be set at a $25,000 cash surety bond with the conditions, and this is the felony file. The conditions that he appear as ordered to keep contact information current, not leave the state without permission, and to commit no new crimes. No alcohol, be subject to daily testing for that. I believe that's appropriate. No illegal controlled substances along with recreational marijuana, and you'll be subject to random testing for that. Now, Mr. Shantz, if something happens that Mr. Bell is not able to post bond, I would not be opposed to a motion being filed for release for treatment. I am somewhat familiar with Mr. Bell's past, having been in the system, having myself been in this system for a while. So I am aware of the struggles that he does face. In regards to case number 254028 ST, I am going to set a bond in this case more so because it is a fail to stop after a collision, and also so he receives credit on this case. If I were to set a PR bond, he would not receive credit if he were not able to post bond in the other file. So bond in this matter will be a $500 10% bond with the condition that he appears ordered to keep contact information current, not leave the state without permission, and to commit no new crimes. Mr. Bell, if you are able to post bond,
Yes,
you need to make it over here to community corrections and get signed up for your testing requirements. And
Today?
again, I'm sorry?
That'd be today, because it won't, my wife gets out at 3, and then that's when she'll come get me.
So they'll be open till 4:30. If you're not able to get here before that, you'll need to report immediately first thing in the morning to get signed up for your testing requirements. Okay? Anything else for the record, counsel?
No, thank you.
No, Your Honor, thank you.
All right, thank you. Next to Raymond.
Your Honor, so if he posts bond before or after they close, we can release him, or you wanna wait till in the morning?
No, he can be released. He'll just need to sign up for testing first thing in the morning.
Okay,
Thank you, John.
All right. Person at the jail, please state your name for the record.
Amber Rudolph.
All right, this is case number 254251FY, the people of the state of Michigan versus Amber Elizabeth Lee Rudolph. Ma'am, you met with somebody from Community Corrections today and gave them some contact information. Was that information accurate?
Yes, sir.
And did you have the opportunity to meet with somebody from the defender's office today?
Yes.
I have a complaint that alleges that between the dates of January 1st, 2025 and February 28th, 2025 in the city of Cadillac of Wexford County, it is alleged that you committed the offense of criminal sexual conduct second degree. That is that's a felony punishable by up to 15 years in prison, along with mandatory AIDS and STD testing and DNA to be taken upon arrest. Do you understand those charges and potential penalties?
I do. I understand them.
On felony complaints, you have certain rights. You have the right to remain silent. Anything you say or write can and will be used against you. You also have the right to have an attorney present during any questioning you consent to, and the right to stop answering questions at any time. You also have the right to be represented by an attorney at all phases throughout this process. And if you could not afford one would be appointed to represent you at public expense. However, you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of one?
Appointment of one.
All right, the court will make a referral to the public defender's office for the appointment of an attorney. We'll enter a not guilty plea and we'll set the matter for a preliminary examination. That's a hearing that's held here in the district court within 21 days. At that hearing, the prosecutor will be required to prove two things. One, probable cause that the crime had occurred. Two, probable cause that you were the person who had committed the offense. If the prosecutor is not able to do that, the case will be dismissed. But if they are able to do that, you'd be bound over to stand trial in circuit court. Prior to that preliminary examination, there'll be a probable cause conference. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments and the threat that you pose to the public. Counsel, I do not show any prior history for Ms. Rudolph, and the praxis scores her at a risk level 3. Any comment regarding bond, Mr. Schatz?
Thank you, Your Honor. She expressed to me that she had already bailed out. Is that anything you guys have a record of?
If she had
No, I
bailed out,
didn't
she
mean it
would-
like that. I'm waiting to get arraigned, and then the bail bondsman wanted me to set up a bail for them, but as far as I knew, bail was 25,000, so we were gonna pay the 2,500 to get me out on the 10% on the bail's bond, depending on
There
what
was
it
an
was.
interim. There was an interim bond set at 25,000.
Okay, thank you for the clarification, Your Honor. Amber expressed to me that she lives in Indiana, in Griffith, Indiana. I'm not exactly sure where in Indiana that is, but that she's been living there for about a year and a half, and that she has 2 children that are living with her, aged 5 and 6, and that she is currently applying for disability. And she currently has several other, she expressed to me that she had some medical concerns about remaining in jail for medication or in Indiana, as well as ongoing medical appointments she has scheduled. I believe she has surgery, she explained, coming up. And then she also has, she is, I don't know if there are legal circumstances surrounding the father of those 2 children and her, where she is not the defendant, in another state that she is hoping to be able to attend in order to see justice delivered on those, in those cases. I don't want to say more, but I don't know if I can. So we understand the seriousness of the charge and should be open to any sort of condition that might alleviate the court's concerns about her appearance. I think, we would request a PR bond, but in the alternative, a small monetary amount, so that she may attend those proceedings. Thank you, Your Honor.
Was she extradited or did she turn herself in?
I believe she turned her, or I believe she was
I did not turn myself in. I was called by CPS in Michigan to go and pick up my children in Lake County. I was expedited from Lake County to Wexford County, but I did not resist arrest. I had not been a problem or anything, and I don't have a problem coming back for any prior court hearings either, or future court hearings.
Without getting into any detail, the children that Mr. Shantz referenced, were those the children that you went to pick up, or are those different children?
Yes, the ones I went and picked up was the 5 and 6 year old. Yep.
All right. Ms. Lawrence?
Thank you, Your Honor. Just to clarify, I believe the victim in this case is 11.
So I think we're talking about two different groups of kids.
Okay, I just wanted to make sure.
Yeah.
Correct me if I'm wrong, Mr. Shantz, but when you said the case that's pending with somebody else, that she's not the defendant, those are the other two kids that she came up here to pick up.
Yes, right, yeah, I believe so.
Correct.
Okay. Thank you. The victim in this case is the defendant's minor son. So I will bond up to the description report.
Just a moment. All right, Ms. Rudolph, as a condition of your bond, you are to appear as ordered, keep your contact information current, commit no new crimes. You're not to have any unsupervised contact with anyone under the age of 16. You are not to act in any threatening, intimidating, and harassing behavior.
So does that mean I cannot pick up my 5 and 6 year old because their father's incarcerated?
As of right now, I'm ordering no unsupervised contact with anybody under the age of 16.
Okay.
So
I live with my partner, so would that still be considered supervised?
you can talk to your attorney about those logistics, because I cannot give you legal advice. All right.
Okay, that's fine.
Bond will be set at $25,000 cash surety. Ms. Rudolph, where is Griffith, Indiana?
Griffith, Indiana is 4 hours from here.
So it's down by the line, the state line,
Yeah.
roughly. Do you have anybody in Michigan you could live with?
I do not.
I will allow travel to Griffith, Indiana. But the defendant will be placed on a GPS tether, house arrest, services, or with conditions set by community corrections. Defendant is not to be released from jail until she is placed on the tether.
I got a question.
Yes,
So bond's still the 25,000 and I have to have a tether.
correct.
Okay, I just wanted to clarify. Thank you.
And you're on house arrest, so community corrections is you're gonna have to communicate with community corrections ahead of time if you want to go anywhere, and they're gonna have to approve your travel and your return instructions. You understand that?
Yep. So every time I leave the house to a doctor's appointment, contact them and come back.
Before you go, you'll need to contact them. Ms.
Okay.
Lawrence? Oh, also, I'm gonna order a no contact with the alleged victim in this case, whose name will appear in the order, but whose first initial is a Z. Anything else, Ms. Lawrence? Mr. Shantz?
No, no, Your Honor.
All right. Ms. Rudolph, once you're able to post bond, if it's after community corrections closes, you'll have to wait until they get over there tomorrow or whenever it is next for your release, okay? Because you'll need that tether on before you can leave the jail.
What time do they close?
They close at 4:30 is when they close, so. But that's no guarantee they'd be able to get over there before 4:30 if you were able to post bond right away, so. All right?
Okay. Okay.
Next to Raymond. The court calls this a financial review. Chris Shank. Mr. Shank was set to appear for notice of arraignment on a bench warrant at 1:30. It is now 2:36. He does not appear. Bond was posted in this matter in the amount of $300. The court will forfeit the bond. Person at the jail, please state your name for the record.
Brandon Terry Baird.
This is case number 26-1522 FY, the People versus Brandon Terry Baird. Mr. Baird, you met with somebody from Community Corrections and gave them some contact information. Was that information accurate?
Yes, sir.
And did you have the opportunity to meet with somebody from the Defender's Office today?
Yes, sir.
I have a complaint that alleges that on or about April 26, 2026, in the city of Cadillac of Wexford County, it is alleged in count number 1 that you committed the offense of domestic violence, third or subsequent offense. That is a felony punishable by up to 5 years in prison and or a fine of $5,000, along with consecutive sentencing possible if it happened in place of confinement. Additionally, the prosecution is elected to charge you as a habitual fourth offender, meaning that you have at least 3 prior either attempted or completed felonies in your past. That makes that 5-year felony a life offense. Do you understand those charges and the potential penalties?
Yes, sir.
On felony complaints, you have certain rights. You have the right to remain silent. Anything you say or write can and will be used against you. You also have the right to be represented by an attorney at any questioning you consent to, and the right to stop answering questions. You also have the right to be represented by an attorney at all phases throughout this process. And if you could not afford one would be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
I'd like to request an appointed attorney.
All right, the court will make referral to the Public Defender's Office for the appointment of an attorney. Will enter a not guilty plea and will set the matter for a preliminary examination. That's a hearing that's held here in the district court within 21 days. At that hearing, the prosecutor is required to prove two things. One, probable cause that the crime had occurred, and two, probable cause that you were the person who committed the offense. If the prosecutor is not able to do that, the case would be dismissed, but if they are able to, you'd be ordered to stand trial in circuit court. Prior to that preliminary examination, there'll be a probable cause conference. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments and the threat that you pose to the public. Historically, counsel, in 06, I show an attempted assault and battery along in 06 with a retail fraud third. 08, attempted malicious use of a telecommunications device. 08, chemical agents prohibited use. 08, attempted felonious assault and a domestic. 09, retail fraud third, and 10, retail fraud second. 10, malicious destruction of property less than 200. And 11, an operating while visibly impaired. Also in 11, an operating while intoxicated. In 13, it looks like there's 2 attempt assault and batteries. In 14, an attempted resist and obstruct and a domestic. In 15, a domestic second. 16, an attempted assault and battery. In 16, an assault and battery. 18, domestic. 19, possession of meth. 18, possession of marijuana. Looks like 3 convictions and 18 for assault and battery. 19, a malicious destruction of property less than 200. And in 24, an assault and battery. The Praxis scores him at a risk level 4. Any comment regarding bond from the defender's office?
Thank you, Your Honor.
Mr. Bard expressed to me that he is from the area. He grew up in McBain, attended McBain High School. He spent his whole life in the Wexford area. Although he's only been living in his current residence for 1.5 years. His entire family lives here. They all went to McBain High School as well. His son is 8 years old and goes to school here. I believe son. He goes to school here in Cadillac. And I say all that to say, obviously he's facing a life sentence. And I believe the court is concerned that he may be a flight risk because of that. I do not believe he would abandon his child or all his family or the place he's called home his entire life. He's never run from charges before, and I believe he intends to face these as he's done in the past, as you covered his entire record. He informed me that he has never failed to appear, and I have no reason to believe him on that, or no reason not to believe him on that, excuse me. And that he would comply with any sort of non-contact order with either the alleged victim or the address. And that he would comply with any sort of drug and alcohol testing as well, if that would appease any of the court's concerns as well, in order to grant him respectfully a personal cognizance bond. Thank you.
Thank you, Ms. Lawrence.
In this case, the defendant is alleged to have pushed the victim onto a bed. He then proceeded to get on top of her, and the victim stated that she tried to fight him off, and she eventually had to fight him in order to get him off of her. There is alcohol alleged to have been involved, so I would ask the court to impose random alcohol testing. I do think a monetary bond is appropriate in this case. I believe I counted 14 assaulted prior convictions. Some of those are multiple convictions within the same year. I think he clearly is a risk to public safety with all of his prior convictions for domestic violence, assault, felonious assault, RNOs. There's several. So I would ask at a minimum the court impose a $10,000 cash surety bond, and I would also ask for no contact order with the victim.
Thank you. The court finds that Mr. Baird presents himself as a threat to the community. I believe I counted 14 or 15 prior assaultive crimes going back to 2006, with the most recent being in 2024. And that does not take into account the malicious destruction of property cases. So I believe a monetary bond is appropriate. Bond will be set at a $25,000 cash surety bond with the conditions that Mr. Baird appears ordered, keeps contact information current, not leave the state without permission and to commit no new crimes. Because alcohol is reported to have been a factor in this, I'm ordering no alcohol and random testing. Mr. Baird reports that drug abuse is no longer an issue. But he does have a conviction in his past, so I am going to order no illegal controlled substances, including recreational marijuana, and be subject to random testing. No contact with a person whose initials are MW, whose name will appear in the order. No contact means no contact of any kind, not by phone, text, email, social media, or anybody acting on your behalf. You are not to purchase or possess any firearms or weapons, and not to act in any threatening, intimidating, or harassing behavior. If you are found to be in violation of your bond conditions, you could be arrested without a warrant, brought back to jail, and have your bond revoked. All right, thank you, jail. I'm sorry, anything else for the record, counsel?
No, Your Honor, thank you.
No, Your Honor. All right, thank you. We are adjourned. Thank you, jail. All right, court calls the people of the state of Michigan versus Christy Joy Tucker Fleischfresher, case number 26527 FY. We are here for a continuation of preliminary examination that was started back on April 8th. Parents of counsel?
Brendan Maturin for the people, Your Honor. You're in favor for the defense.
All right, you may be seated, or do we have any preliminary matters before we begin?
Judge, Mr. Faber approached me before court this afternoon with a bond matter. We'd like to go ahead and take that up now if we could.
Okay,
And if I may approach, Your Honor, I have a
you
copy.
may.
This Tucker is on the board of the Northern District Fair here in Cadillac. She's actually the director.
Okay.
She's been instrumental for the past 3 years in the spring carnival that's about to take place this week, starting Thursday. The defense is humbly requesting her ability to appear for the hours specified in my motion. Either work in the ticket booth or concessions or the speed office. Thursday and Friday from 3 p.m. to 11 p.m., Saturday from 10 a.m. to 11 p.m., and Sunday from 10 a.m. to 9 p.m. And again, she's a lifelong member of the community. She is on the board. There's also a deputy that's on the board of directors also. So there would be law enforcement present with her. She is not a flight risk, and we are asking the court to grant this slight modification to her bond.
All right, thank you, Mr. Matern.
Thank you, Your Honor. Given that the request is fairly limited in duration, obviously the defendant's not asking to leave the community. She's on the tether. As long as she coordinates this with community corrections, of course, the people do not object to this request of modification.
All right, I will grant the request and it's presented. Can we get that in a modification, or do you want defense draft motion or the order?
I can just change her PTR.
Okay,
Yeah.
so we'll change the pretrial release order and we'll make sure community corrections get a copy of that to allow for the requested hours and times.
Thank you very much, Your Honor.
All right. Any other preliminary matters we need to discuss?
No, thank you, Your Honor.
No, thank you.
All right, your next witness then.
The people called Bruce Messer.
You swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth.
I do.
All right, you may have a seat. Whenever you're ready.
Thank you, Your Honor. Sir, will you please state and spell your name?
Bruce Messer, first name is B-R-U-C-E, last name M-E-S-S-E-R.
Mr. Messer, are you employed?
Yes,
Where are you employed?
by the state of Michigan in Grand Traverse County with the Department of Licensing and Regulatory Affairs.
Is the Department of Licensing and Regulatory Affairs, otherwise known as LARA or Lara?
Correct.
Were you employed with Lara in November of 2022?
Yes,
What were your job duties with Lara at that time?
I'm an adult foster care licensing consultant.
What does that mean? Can you explain that to the court, please?
I oversee the licenses issued by the state of Michigan to adult foster care. So, I'm with the licensee on compliance of rules, investigate allegations of non-compliance.
And what is an adult foster care?
Adult foster care is a licensed facility designed to care for individuals 18 years old and older that are unable to safely reside in their own home. So they may choose, or if they have a guardian may choose to put them in this type of facility, generally for safety reasons, safety and healthcare.
Is it different than like a skilled nursing facility, a so-called nursing home?
It is a skilled nursing facility, is just what the name implies. A nursing facility, they have medical, licensed medical professionals on staff. Adult foster care home does not take care of people that require 24-hour skilled nursing care. It's maybe a step lower as far as services provided, and the needs of the residents are not as great as they would be in a skilled nursing facility.
You mentioned that people that live in adult foster care, they're not able to live on their own. Do they require some degree of medical care?
Generally speaking, they all do, yes.
Would that often include, making sure that they receive medications as prescribed?
Yes.
Would it also include monitoring, the residents' condition in terms of their well-being and their general health from day to day?
Yes.
Are these things that are covered by the rules that you mentioned?
They are, yes.
And where do those rules come from?
They're, Public Act 218 of 1979 is the law that governs it. From that, the state has devised a rule set.
So
in which the
Public Act-
licensee
I'm sorry.
must comply. Sure.
Public Act 218 is the statutes that create this entity called an adult foster care.
Yes.
And then also authorize and basically task Lara with providing regulatory oversight of adult foster cares.
That's correct.
And then give Lara authority to promulgate rules to carry out its mission with respect to these facilities.
Yes.
Okay. And back in November of 2022, did you become involved, or possibly it went into October, December and January of 2023? Were you involved in an investigation at a facility called Pleasant Lake Lodge here in Wexford County?
Yes, more specifically, Pleasant Lake Lodge South. There's two licensed facilities on a single campus, one being Pleasant Lake Lodge North. That's a separate license from Pleasant Lake Lodge South.
Okay.
What you're referencing would be Pleasant Lake Lodge South.
Thank you for the clarification. So Pleasant Lake Lodge South, was that an adult foster care facility?
It is.
And was licensed as such at that time?
Yes.
And how did you become involved with an investigation at Pleasant Lake Lodge South at the end of 2022, beginning of 2023?
Yes, our department had a complaint allegation made to us. We initiated an investigation. I was unable personally to initiate the we call them special investigations on the complaint. My colleague Rhonda Richards, who works with me in the Traverse City Lara office, initiated the special investigation, conducted some preliminary interviews, and conducted a on-site investigation at that facility.
And what was the nature of the investigation?
The allegation?
What was the allegation?
And referencing the report that my colleague Rhonda Richards had made. So the allegation was that the facility, Pleasant Lake South, did not give a resident her insulin as prescribed.
And then what happened to that resident?
She died about 5-6 days after admission to the facility.
Okay, are we referring to Kelly Harris here?
Yes.
What is a licensee designee?
Yeah, in this case, the license is issued to a corporation, Pleasant Lake Lodge Incorporated. So as a licensing consultant representative of the state, I need a human being to talk to. So the corporation then appoints what we call a licensed designee. So that human being designated by the licensee, in this case, the corporation. And that, I think that answered your question.
So is the person designated as the licensee designee, are they essentially the spokesperson for the facility?
Correct. They're the ones designated by the license holder to have the responsibility to act on behalf of the license holder, in this case, the corporation.
Okay.
Yeah.
So at that time, who was the licensee designee for Pleasant Lake Lodge South?
Christy Tucker.
Flesh presser?
Yeah, I always twist my tongue on that.
Is she the defendant in this case?
I'm sorry.
Is she the defendant in this case?
She is.
She's seated here in the courtroom with her attorney at counsel table?
Yes,
Okay, and you've met Ms. Tucker Fleischfresser before?
yes.
Okay, so give me an overview, please, of the investigation that you conducted at Pleasant Lake Lodge concerning the death of Kelly Harris. Just sort of a general description of what the steps that you took in that investigation.
Yeah, as I noted, the Department of Licensing and Regulatory Affairs Adult Foster Care Licensing Division received a complaint that the resident had not received her insulin, prescribed insulin as ordered by her physician. So my colleague, Rhonda Richards, initiated the investigation, went to the facility, conducted interviews with Ms. With Christy, I'm just going to say Christy. And Ms. Richards also spoke with emergency medical technician that had responded at the time of the resident's death. And Ms. Richards also had spoken with the medical examiner's office and received the medical examiner's investigation report. In early January, I provided some assistance in conducting the interviews with various facility staff members, and then worked with Ms. Richards to finalize the report.
So among the staff members that you interviewed, did you interview Valerie Glendeming?
Valerie Glendering.
I think honestly you have it's misspelled in your
Okay.
report, but.
Yes. I think we're talking about the same.
Okay.
Yes.
Did you interview Allison Schulten?
Yes.
And did you interview Christopher Larive or Larive?
Yes.
And did you interview Angela Adams?
Yes.
Did you also interview the defendant?
I did. Yes.
Did Laura make a determination as to the violation concerning administration of prescribed insulin?
We did, yes.
What was the determination?
The determination was made that the licensee failed to comply with the rule governing medications, specifically providing the medication as prescribed by the resident's physician.
Now, to clarify, does that finding actually apply to two different types of insulin that were prescribed for Kelly Harris?
It does. There were two medications or two insulin, different types of insulin prescribed. One was Lantus, one was Aspart. I don't know if I'm pronouncing that last one correctly. And as a result of the investigation, the department determined that neither of those two medications were provided to the resident as prescribed.
What did you said you interviewed the defendant? What did she say about administration of insulin to Kelly Harris while Ms. Harris was a resident at Pleasant Lake Lodge South?
Yeah, I'll answer your question specific to each of the two different types of insulin. Christy had indicated that the Aspart, which is a sliding scale, that the amount dispensed is determined based on blood sugar level readings. She had indicated that that prescription never was filled by the pharmacy, and the facility never had that medication to dispense. She indicated that she tried multiple times to acquire that medication. And was unsuccessful in a short period of time. The resident resided in the home. As far as the Lantis, refer here. As far as the Lantis, Christie had indicated to the department that, or to me during an interview that I conducted with her, that the Lantis was being administered to the staff, and she made that statement based on a record that the facility keeps without medication administration record. So based on the MAR, indicate that the staff did provide that medication.
But but to clarify though, despite her saying that, Laura actually found that the facility did not administer Lantus insulin to Kelly Harris, correct?
Right, and that's correct.
Okay. Were there any other, so there was those two violations related to the two types of insulin. Were there any other violations of applicable rules established by Laura in connection with this investigation?
Yes.
What were-
The first was in regards to, again, following the instructions of the resident's physician. One of the instruction was monitor the resident's blood sugar levels. Okay, the department found that that was not occurring. So we cited the rule stating the licensee must follow the instructions of the resident's physician. The other was in regards to seeking care for a resident when there's an adverse change of their physical condition. Throughout the state at the facility, the resident was vomiting and experiencing other medical conditions that the department felt the licensee should have followed up directly with the resident's physician to inform them that this resident is vomiting and showing other signs of medical distress. So that rule was also cited.
And the specific rules promulgated by Laura that were, the violations were established regarding those rules are they cited in the Laura report?
They are.
As to the specific rule number?
Rule 310(1)D is the rule in regards to monitor the resident's blood sugar levels. Rule 310(4) is the rule that requires, in case of an accident or sudden adverse change in a resident's physical condition, that the facility shall obtain needed care immediately.
Okay, and then the rules regarding administration of prescribed medications, that rule is also cited in the report
Yeah,
as well?
actually, yeah, two separate rules concerning the medication. Rule 310(1)A speaks to the licensee shall follow the instructions and recommendation of a resident's physician in regards to medications. And Rule 312(1), very similar language, prescription medication shall be given, taken or applied as prescribed.
Thank you. Did the defendant, Ms. Tucker Fleischfresser, did she make a statement to you regarding whether she had entered either the Lantus insulin or the Aspart insulin into the facility's MAR system?
Can you repeat your question?
Did she make a statement to you regarding whether she had entered the Lantus insulin into the facility's MAR system?
She had, yes.
What was the statement? What did she tell you about that?
Yeah, that she had recorded the Lantus along with several other prescription medications into the computerized system as a medication to be dispensed.
Was that statement consistent with the statements that you obtained from the other people you interviewed?
Well, let me clarify what I just stated. So when a resident comes into the facility, they have a listing of medications because Pleasant Lake Lodge South has a computerized system. Christy informed me that she had entered all those medications into the system. What I didn't say is that was anything in regards to were those medications dispensed or not. If you want to clarify your question, your next question.
I was just asking whether she said she had put the Lantus insulin into the MAR system.
Yes, as one of the medications to be dispensed.
Okay.
Yeah.
If you, just a moment, please, Your Honor.
Sure. Mr. Messer, while he's looking, I can't help but know, it looks like you're reading off of something. Is that the LAR report that
It
you're
is.
reading? Okay.
It is, yeah.
Thank you.
Yes, sir.
Judge, and I would note that report is actually part of People's Exhibit 2 that's been admitted.
All right.
It's towards the, and again, I apologize that I forgot the Bates number of these pages, but it is towards the end of Exhibit 2. So,
Is that the January 10th?
yes. Yes, Your Honor. Yeah, it starts with a cover letter from Laura addressed to the defendant and dated January 10th.
All right. Thank you.
And I do not have any further questions of this witness at this time.
All right, Mr. Faber.
Thank you, Your Honor. Good afternoon, Mr. Messer.
Good afternoon.
So you began the investigation, your special investigation on January 16th of 23?
Well, the investigation was initiated November 16th, 22.
Okay. What, on your report, what's the date, 1/16? What is that the date of the report?
January 16th? What are you referencing?
Page 1 of identifying information. Starts, it's a table, it starts as license number. So I can move on.
Okay.
So special, or Pleasant Lake Lodge's South license number is AL 83. And AL stands for Adult Large Group Home.
Correct.
So it's licensed, as you said, under, you said PA 218, 1979. I think that was codified under Michigan compiled laws 400.701 and then by sequence beyond that. The Adult Foster Care Licensing Act, is that correct?
That's correct.
Okay. So Pleasant Lake Lodge South is not licensed under the public health code, is that correct?
Correct.
Because an adult foster care facility is not necessarily a healthcare provider by statute unless it's licensed as such.
Well, I guess I would object to that calls for a legal conclusion, Your Honor.
Well, it's
If
statutory.
he's able to answer it, that's fine, but
Are you able to answer the question?
That's beyond my scope.
Let me ask you this, if like a nursing home that's not licensed under the Adult Foster Care Act, that's licensed under the Public Health Code.
Correct.
Because.
That's my understanding, yes.
Okay, that answers my question in a different way. Pleasant Lake Lodge South had no licensed physicians.
Correct.
No licensed registered nurses, LPNs.
Correct.
Physicians assistants, pharmacists.
Let me answer all those questions by saying the adult foster care licensing rules do not require any of those positions to be on staff. Now, whether they had LPN hired as a direct care worker, I don't know that one way or the other.
Okay, if it was testified to that there were no such licensees, you wouldn't have, that wouldn't be a violation of the Adult Foster Care Act, right?
No, it would not be, not required.
And Christy, I'm gonna go with Christy as well. Her last name is a tongue twister. She has no such licensure, correct? To your knowledge?
Not to my knowledge.
And that's not required.
Not required. So I wouldn't ask beyond what the requirement is.
Did your investigation yield that Munson Hospital, when it discharged Ms. Harris, provided a number of her prescribed medications, but did not provide Ms. Harris with her Aspart, the sliding scale insulin?
That's what the investigation revealed, yes.
Okay. She was provided the long-acting Lantus.
Correct.
Did Christy indicate to you that she herself entered those medications into the QuickMar system, or if she believed that somebody on her staff entered the medications into the QuickMar system?
She indicated to me during my interview with her that she entered all of the residents' medications into the MAR.
Okay, was that distinction, was that fleshed out at all? You just assumed that what she told you was that she herself typed it in?
That was my understanding.
Your assumption
based on what we discussed during the interview, and that's what I documented in the report. So.
And you testified that you were aware that from the date of admission into Pleasant Lake Lodge, that Christy was actively trying to contact the pharmacy to get that missing Aspart, correct?
Correct.
Right. And you confirmed that, you talked to Mr. Dickerson from the pharmacy?
Correct.
And so now so the pharmacy is also working on filling the prescription.
They were.
And the pharmacy, to your knowledge, had contacted Munson Hospital representatives.
Correct.
To try to get that prescription filled.
Correct.
And I think in your report, it indicated that Munson did not reply to the pharmacy.
Correct.
Were you aware of the concern with the prescription having been filled out by a third party and not one that this pharmacy would be able to fill the way it was provided by Munson Hospital?
Could you repeat the question?
Well, I'll ask you, were you aware of what the issue was with the Aspart prescription that led to the difficulty in it getting filled?
The circumstances of why it wasn't filled?
Correct.
Yes, during the investigation, yes, I became aware of the circumstances of why it wasn't filled.
Okay, and Christie had nothing to do with the circumstances surrounding why there was so much difficulty getting the pharmacy to fill this prescription, correct?
Correct.
Would you say that your special investigation, because you reference at least 2 other staff members were unaware of or not monitoring, it's safe to say your investigation was not based solely on the actions of Christie, but on the foster care facility itself, correct? Including its staff members.
Correct. All the actions of the staff, the investigation focused on.
So you'd agree that the violations that you determined were broader than Christie's actions or inactions alone. It was a systemic problem, correct?
Correct.
You indicated that one of the violations that you found was a failure to provide care when there was a change for the worse in Ms. Harris's condition.
Yeah.
The vomiting, the stated distress that she was experiencing. Did your investigation determine, and there's been testimony from the past hearing, that the days where that distress was being revealed, those were 2 days, Thursday and Friday, the 3rd and the 4th of November, where those 2 days, Christie was actually not working at the facility on those 2 days. She was relying on her staff managers to run the facility day to day on the days that she's scheduled to be off.
Yeah, I don't know the particular of your question, if she was not working on those days, but yes, it's very common for the licensed designee or the administrator of facility to rely on a home manager or a lead staff member to run the operations on days that are not scheduled to work. That's the norm, I would say.
Okay, and thank you. And is that's probably why in your report, the violation was that the facility failed to provide care when they noticed a change for the worse in Ms. Harris's condition, correct?
Yeah, correct. The license holder is ultimately responsible for compliance. In this case, the license holder is the corporation. So that's who we cite.
And so what are the possible sanctions available to you? Because you have a tremendous amount of power through your investigation to determine if there is a violation, what the proper sanction should be, correct?
We do, yes.
And can you go through the spectrum in terms of most modest sanction to most serious sanction that you have the ability to recommend?
Yeah, if we find violation of a licensing rule, we, as you stated, we have various options we can choose. One being we can leave the status of the license as is, for instance, a regular license, but we would request that the licensee provide a corrective action plan that's acceptable to the department and then successfully implement that corrective action plan. Another option we have is to place a facility on a 6-month provisional license. And with that, we would also get a corrective action plan and expect the licensee to successfully comply or successfully implement that corrective action plan. Again, that's for 6 months. The department would then reevaluate at that 6-month period to see if they are in compliance, full compliance then with the licensing rules. If so, we would put them back on a 2-year regular license. There are times when there may be an extension of that provisional for another 6 months of monitoring. Another option we have is to revoke the license, and there's 2 ways to do that. One, we do a summary suspension, which essentially is closing the facility down on that day, and then you do the due process afterwards. And the other revocation is you notify the facility that the license is going to be revoked, but they still can operate while the due process proceedings are carried out. So those are the 4 options that we have. Yeah.
So if I
4 or
understood
5
you,
minutes.
if I understood you correctly, the sanction that was imposed for the violation that you found was at the lower end of possible sanctions in this case.
Correct.
Corrective action plan?
Yeah, the department put the facility on a 6-month provisional license. Had the licensee do an corrective action plan and implement that plan.
And was that plan implemented?
It was.
And was the facility re-reviewed after 6 months?
It was.
Any further compliance issues?
No.
What is the status of her license today?
Today, it's a regular 2-year license.
Since 2022, have there been any other allegations or investigated activity of Pleasant Lake Lodge South by your agency?
Yes.
Since that time?
Yes. In the summer of 24, May and July of 24. Not related to medication. None of the issues were related to resident medication or resident care.
And was there any violations discovered in the summer of 2024? Anything that required corrective action?
Yes. What I just noted. Yeah.
Well, what was that?
Issues with staff training, staff. I don't have the reports with me. I'm just going off a little summary sheet that we have. Staff training issue was cited. A staff member did not have their physical exam completed. A staff member had not had their criminal background check completed. And rules related to resident treatment, although I can't give you specifics on that because I do not recall what that was. And then with that same investigation in regards to resident treatment, there was another staffing issue with adequate staffing. Again, I don't have the reports, so I can't give you any details whatsoever on those. And those were May 2024, July 2024. So.
Did you do that investigation yourself?
The one I did, the July 2024, I did that, and the May of 2025, another colleague of mine, Adam Robarge, out of our Petoskey office, did that.
Would you have access to those records and provide it to the prosecutor?
We would have both those reports in our files. Yes.
Thank you. I have no further questions.
Just a few on redirect, please, Your Honor.
Go ahead.
We had talked about the fact that the defendant was the licensee designee for Pleasant Lake 5 South. What was her actual job title or position there?
Well, her position was licensed designee administrator of the facility.
She was the administrator then?
Yes.
Okay. As the administrator, is she the person in charge of the entire facility?
Yes.
So she's the one, basically the buck stops with her.
Correct.
She's responsible for the care that's provided within the facility.
Yes.
Okay. That's all I have, Your Honor.
Any recross?
No, thank you.
Let's see if I have any questions. Is there anything in the statute that Pleasant Lake Lodge is licensed under that would indicate who's responsible to determine whether or not somebody should be taken to the ER if their health deteriorates?
Well, Your Honor, the rule. On page 6 or page 8 of the report, Rule 310, paragraph 4, it speaks to a group home shall obtain care immediately. Going back to questions that was just asked, where does the buck stop? You know, when it says the group homes, you know, ultimately the licensed designee administrator has that responsibility. If they're not on site or working per se, then the expectation would be that they have appointed someone that has that responsibility or that the capabilities to make those decisions.
Was there, go ahead.
Such as a home manager. Oftentimes facilities may, you know, they'll have a licensed designee and / administrator. And then if they have multiple facilities, they'll have a home manager kind of in charge of them, the direct care staff that are working in that particular facility. So maybe the company may have multiple home managers, you know, one for each facility.
In your investigation, was there any indication that Pleasant Lake Lodge had that sort of hierarchy?
Yes, the one staff, I have to reference again my report to see who that was. Yeah, and Amber Harris was designated as the home manager. I referenced that in the interview with staff member Valerie Glendering, who indicated that she had contacted home manager Amber Harris. That's on page 5, kind of in the middle of the page there.
Council, does that raise any additional questions?
I hopefully just one or two, Your Honor.
All right.
Is it the administrator's responsibility to ensure that all of the staff are trained to report a change in a resident's condition to either somebody who can provide medical care or somebody above them, so to speak, in the chain of command at the facility?
Yes, administrator is responsible to ensure that everybody working in the facility is fully trained in accordance with the requirements of the licensing rules, be it a home manager, a direct care staff, or anybody working in the chain of command below the administrator. That the administrator license designee, the licensee ultimately, yes, is responsible.
Okay, thank you.
Like you had stated, the buck stops with the license designee.
Okay, thank you. That's all I have, Judge.
Mr. Faber?
Sure. The buck stops with the licensee designee Christie for Laura regulatory purposes, correct? To comply with the licensing rules.
Correct.
You're not giving an opinion about legal criminal
No.
responsibility.
No, from a licensing standpoint, the individual that has to answer to the state is the licensed designee.
Nothing but.
Redirect.
No, thank you, Your Honor.
All right, may this witness be excused?
Yes, Your Honor. Yes, Your Honor.
All right, you're free to go about your day. Thank you.
Thank you.
Your next witness?
Thank you, Bruce. People call Michigan State Police Trooper Patrick McClure.
Trooper, you raise your right hand. Do you solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
You may have a seat, and whenever you're ready.
Thank you, Your Honor. Please state and spell your name.
Trooper Patrick McClure, Patrick McClure.
Are you with the Michigan State Police?
I am.
How long have you been with MSP?
I've been with MSP for 4 years and have 13 years of law enforcement experience.
Where were you before you came to MSP?
I was with the City of Everett Police Department for 7 years and Lathrop Village in Oakland County for about a year and a half.
And did you go through, is there special training that you received in order to become a trooper?
Yes, I went through the Michigan State Police Recruit School, and prior to that, I went through the Wayne County Regional Police Academy back in 2011.
Does the training include conducting interviews with suspects and witnesses?
It does.
And have you conducted interviews with suspects and witnesses throughout your law enforcement career?
Numerous, yes.
Any idea how many times?
Over the course of 13 years, 50 to 100 at least.
All right. Did you become involved with an investigation concerning the death of a lady named Kelly Harris at an adult foster care facility here in Wexford County, named Pleasant Lake Lodge South?
I was involved in that, yes.
What was your involvement in that investigation?
I assisted Trooper Kennedy with an interview reference this incident.
And what's Trooper Kennedy's full name?
Logan Kennedy.
Okay.
Logan Kennedy.
Do you recall when that interview took place?
I believe it was February 6th of 2005.
25?
Yes, yes.
Okay.
I'm sorry, yes, yes.
And who was interviewed that day?
I can't, I was butchering the last name, Fleischer.
Was the interviewee the defendant in this case?
Yes.
And is she seated in the courtroom right now with her counsel at counsel table?
Yes, sir.
And what were the circumstances of the interview? In other words, where did it take place? How did it?
The interview took place at the Michigan State Police Cadillac Post in the conference room. I joined shortly after Trooper Kennedy had started speaking with the defendant, and had stepped in roughly, I believe, somewhere between 5 and 10 minutes after the interview had already taken place.
Was the interview recorded?
It was recorded via Trooper Kennedy's body-worn camera.
To your knowledge, was the defendant aware that it was being recorded?
To my knowledge, yes.
Was the body cam visible on the table or in the room?
It would have been either, I don't recall correctly, if it was on the table, it would either been on the table or worn on Trooper Kennedy's chest.
Okay. To your knowledge, the defendant, did she voluntarily agree to be interviewed?
Yes, from my understanding, Trooper Kennedy invited her to the Cadillac Post to conduct a voluntary interview.
Was she in custody at that time?
No.
She was free to leave at any time?
That's correct.
And the interview, did the interview concern the circumstances of Kelly Harris's residency at Pleasant Lake Lodge?
That's correct.
Did the defendant make any comments about accepting Kelly Harris as a patient at Pleasant Lake Lodge, or a resident rather?
I believe she made a statement along the lines of that she had been hesitant to accept her as a resident due to her numerous medical conditions.
All right. Was it your understanding that one of Ms. Harris's medical conditions was diabetes?
That's correct.
Did you ask, was the defendant asked during the interview whether Ms. Harris's blood sugar levels were checked while she was a resident at Pleasant Lake Lodge?
I believe she was asked that, and I believe that her response was that the resident was supposed to be checking her own insulin and be informing the staff when her blood sugar was off.
So did she indicate whether the staff actively got involved in checking the blood sugar levels?
I don't believe she said the staff was involved in actively checking. I think it was just that the resident was supposed to inform the staff that she was, when her blood sugar was high.
Okay. Did you talk to the defendant about administration of insulin to Kelly Harris?
I did.
Do you recall what she said about that?
I believe that she said that the insulin had not been administered to Ms. Harris.
Was that a specific type of insulin she was referring to?
It was a Lantus insulin, I believe.
So
there's a name for like an auto clicker, an auto injector insulin. I don't remember the correct terminology for it.
So she was asked if she was talking about Lantus insulin, is your recollection?
Yes, sir.
And she said that Lantus insulin was not administered to Kelly Harris?
I believe that's correct. Yes.
Did you ask her about making a different statement to Laura about administration of Lantus insulin to Kelly Harris?
I had asked her, we had a copy of the Laura report from the incident. And I believe I asked her regarding her statement that she had made to the Laura investigator at the time, which had stated that she had been receiving insulin. I think it was, I can't remember the date when she spoke with Laura, but the statement that she had made to Laura was, the statement that she had made to Laura was not the same statement she had made to us at the time regarding the insulin injections.
She had indicated to Laura that Kelly Harris did receive Lantus insulin, but she acknowledged to you that Kelly Harris did not receive Lantus insulin.
Correct.
Did you ask the defendant about making any changes to Kelly Harris's medical chart after Kelly Harris was deceased?
I did. I asked her if after Ms. Harris had passed away, if she had gone on to make any sort of changes or corrections to the charting system. And she said something along the lines of probably 100% yes, or something along those lines.
Did she state that she went back and added Lantus insulin to the chart after Kelly Harris had died?
She did say that, yes, sir.
Did she also state that she put initials regarding administration of Lantus insulin into Ms. Harris's chart after Ms. Harris died?
Yes, sir. That was a question that was brought along because there was a employee there who had been interviewed at a prior time that stated he had no recollection of his initials being placed on a sort of insulin injection. When asked about that, she had said that she had gone back, and I believe her statement was filled voids. When I asked her further about that, she said that sometimes if things are not marked on there, she'll go back on and check them as if they had been completed.
So she acknowledged that she went back and put other people's initials into the electronic medical record indicating that insulin had been administered to Kelly Harris.
Yes, sir.
Thank you. Did you ask her why she changed the record regarding Lantus insulin being administered to Kelly Harris?
I asked her if she had gone back to change it because she was afraid that she was going to get in trouble. And she had stated, yes, probably. So.
That is all the questions I have of this witness at this time, Your Honor.
Mr. Faber?
Thank you, Your Honor. Trooper McClure,
Yes, sir.
good afternoon.
Afternoon, sir.
So the death of Ms. Harris occurred on November 5th of 2022. Is that your understanding?
From my recollection, yes.
This investigation didn't begin until June of 2024?
I believe so. I'm not the initial trooper on it, but I would think somewhere around that time.
About a year and a half after the death?
Roughly, yeah.
Okay. Do you have any knowledge of the impetus for the investigation so long after the incident itself?
Could you rephrase for me, sir?
What was it that prompted an investigation this late in time after the alleged incident?
I don't know for sure. It's something about Amber Harris, but again, I was the only portion of this was this interview, so I'm not privy to everything that was going on with this.
Okay. Did you interview Amber Harris?
I did not know, sir.
Okay. As a trained investigator, it's not optimal for there to be a year and a half from an incident to when the investigation begins. Is that fair to say?
It wouldn't be a perfect situation, no.
Memories fade.
Sure.
Some evidence is perishable.
Absolutely.
Would you, as a trained investigator, would you agree that in any death case, the greatest determination evidentiary wise in terms of value would be an autopsy to prove cause and manner of death? Would you agree with that?
That would be extremely helpful, yes.
To your knowledge, was it the Michigan State Police that was that the sole agency that did this investigation?
Outside of Laura?
Outside of Laura.
Like law enforcement agency?
Yes.
I believe so.
Okay. So you, MSP relied on the medical examiner's report for cause and manner of death, correct?
That would be my best estimate, yes. Again, I wasn't involved in the beginning, so I believe that it was the medical examiner's report is what they used.
Okay. And to your knowledge, there was no independent medical testing beyond the medical examiner's?
No, not to my knowledge.
I don't have anything further.
Nothing further, Your Honor.
Trooper, if you missed it, I apologize, but did the defendant indicate when she made changes to the medical record system?
I don't recall if she made statements directly to us or not. I believe that it had been days after the incident.
What made you think that it's within a couple days?
I believe it was another part of one of the reports I reviewed, either Trooper Carroll's or Trooper Kennedy's. I don't think that in our interview, she stated a time frame.
Did the interview, was it done in such a way that it would have indicated a time period in which it would have been changed? Do you know what I mean by that?
No.
So were questions done and asked in such a way that made you believe that it was within a certain period of time that wouldn't have required her to specifically state a specific period of time?
If I did, it would be a guess.
Okay.
I wouldn't be able to say definitively.
All right. And when she was making reference to changing the medical records in regards to the Lantis, was that in regards to administration of it or adding it as a necessary medication?
Adding it onto the chart, adding it, so that was in reference to it being on the chart. So when she said adding the Lantus insulin, it was that the Lantus insulin was not on the chart, and then it was then gone on, later added to the chart as being a required medication.
But not necessarily that it was administered.
Correct.
Thank you. Does that raise any additional questions?
No, Your Honor.
All right, may this witness be excused?
Yes, Your Honor. Yes, Your Honor.
All right, thank you. You're free to go about your day. Or I assume he's free to go about his day?
Yes.
All right, go ahead. Your next witness?
Nothing, no further evidence from the people, Your Honor.
All right. Does the defense wish to present any evidence?
No, Your Honor.
All right, argument then.
Your Honor, the people move for bind over as to all 4 counts in the complaint. Judge, it's pretty clear what happened here. Kelly Harris was admitted directly from a hospital. She was a sick individual who probably required a higher level of care than Pleasant Lake Lodge was able to provide to her with no credentialed medical professionals on staff. As Trooper McClure indicated, the defendant herself expressed reservations about accepting Ms. Harris as a resident. And then what happened after that was they proceeded to do essentially nothing for her other than provide her with the prescribed medications that were actually listed in their MAR, which did not include any type of insulin. So basically she was fed, she had a roof over her head, she had probably some assistance with her activities of daily living, but her medical condition was not closely monitored. Again, insulin was never provided to her. And when she became significantly sick, they just let her lie in her bed and die, frankly. And then found her that way on the 5th day that she lived there. As far as the Lantus insulin, all the caregivers who testified that that was not in the MAR, the medical medication administration record, as a medication that needed to be administered to Ms. Harris. So they did not know that she needed Lantus insulin. I believe it was Allison Schulten who testified that the defendant pulled a bottle of Lantus insulin out of the fridge with Kelly Harris's name on it after Kelly Harris was deceased. And all the witnesses testified that they did not know that that medication was available on site to give to Kelly Harris, or that she even needed that medication, although they were aware that she was diabetic. Lara, consistent with those statements, Lara found that a violation related to the failure to give her the Lantus insulin and also the failure to give her the Aspart insulin. If you look on page 4 of the Lara report, Your Honor, pages 3 and 4, it was discussed with the defendant about how the effort to obtain the Aspart insulin, and in a nutshell, what happened was it was not available the day that Ms. Harris moved in on November 1st. The defendant did make some efforts to obtain it that day, and then the following day, the 2nd, but essentially there's no mention of any effort to ever obtain that after the 2nd. Essentially, the efforts were abandoned, and that's why she never received the Aspart insulin. Then, of course, about 2 days later, she became sick. She was vomiting. Her daughter testified that she vomited her dentures into the wastebasket next to her bed. Apparently, nobody found that alarming or even found it necessary to, clean that mess up and give her back her dentures. The evidence is very clear that from shortly after the time she arrived until the time she died, her blood sugar was very high. Dr. Wagner, of course, was unequivocal that the cause of her death was diabetic ketoacidosis, which is what happens when a diabetic doesn't have their diabetes treated and their blood sugar is persistently high over a period of time. And then, of course, the 4th violation that Lara found was failing to monitor her blood sugar. I mean, obviously, it's not disputed that the defendant, that Ms. Harris was monitoring her own blood sugar up to a point, but at the same time, that should have been in the MAR, and they should have at least been asking her about it on a regular basis, and that never happened either. And the defendant acknowledged that when she talked to the state police. So you have basically, you have failure to administer either type of insulin, failure to check her blood sugar or even ask her about her blood sugar, and then failure to respond in any way when she became sick. Which was, again, consistent with onset of diabetic ketoacidosis. So, and then of course, all of the witnesses testified well, Allison Schulten and Valerie Glendenning both testified that they never documented administering insulin to Kelly Harris. The evidence indicates that the defendant went and put that information after the fact, after Kelly Harris died. The document that's the edited MedPass results, that's the last page of People's Exhibit 2, shows that the defendant did that on November 7th, 2 days after Kelly Harris died. Again, Ms. Glendenning and Ms. Schulten testified that whenever they looked in the MAR, there was no mention of insulin, so that anybody else who would have looked in the MAR wondering what, looking to determine what medications Ms. Harris needed would not have known that she needed insulin. There's obviously two witnesses, Mr. LaRive and Ms. Adams, who are no longer with us and not able to testify here, but undoubtedly their testimony would have been the same, that when they went to the MAR to see what medications Ms. Harris needed, there was no mention of insulin. And that's consistent with Lara's findings as well, Your Honor. So with respect to each of the counts stated in the complaint, as to involuntary manslaughter, the defendant indeed had a legal duty to Kelly Harris. She was the administrator and she was the one who made the decision to admit Kelly Harris to Pleasant Lake Lodge. Her signature is throughout People's Exhibit 2 as the person who did the intake. She was the one who received the records from the hospital. The medication list was provided to Pleasant Lake Lodge. That's also in People's Exhibit 2. The medication list from the hospital clearly states that that of course that Ms. Harris was to receive the 2 types of insulin. I don't know if the defendant didn't look at that list or just disregarded it. And in fact, the text messages that the defendant introduced as evidence show that even though the defendant asked Amber Harris to input the medications into the MAR system, Amber Harris states right in the text messages that she did not look at the medication sheet. She only looked at the pill bottles on the counter. So the defendant knew that. The defendant knew that Amber Harris, when she input the medications, did not actually look at the medication sheet, but only looked at the physical pill bottles that were in front of her, which of course did not include any insulin. So she handed that task off and she did not follow through to make sure that it was completed. So again, the defendant had a legal duty to Kelly Harris. She was aware of the facts that gave rise to that duty, which is the fact that she accepted Kelly Harris as a resident of the facility that she was running, that was subject to the rules promulgated by Lara pursuant to the Adult Foster Care Licensing Act. The defendant neglected or refused to perform those duties, as I've already discussed. Basically, they didn't do anything for her with respect to making sure she had insulin or making sure she got care when she became sick because she wasn't receiving her insulin. And frankly, they shouldn't have accepted her as a patient if they weren't prepared to at least do the bare minimum to maintain her well-being. And of course, their failure to do that was in fact grossly negligent to human life. And the failure to do that directly caused Ms. Harris's death. So that's and obviously the defendant's culpable mental state was evidenced by the fact that she lied to Lara and she went back and altered medical records to falsely indicate that Ms. Harris had received insulin while she was alive at Pleasant Lake Lodge. As to counts 2 and 3, falsifying medical records, it's very clearly been established that the defendant deliberately went back after the fact and changed the records to indicate that various people had administered insulin to Ms. Harris when in fact that never happened because they didn't know that she needed it, because it wasn't in the MAR, because the defendant didn't ensure that it got put in the MAR. But then she realized that after she was looking through things, after this resident, turned up deceased in her bed on the morning of November 5th. And then she apparently decided to go back and backfill the record to indicate that something had happened that had not in fact happened. She knew exactly what she was doing. She did that intentionally. She placed false information in Ms. Harris's medical record or chart. She knew that it was a medical record or chart. She knew that the information was inaccurate. Now, was she a healthcare provider? Clearly, what she was providing healthcare. We're not alleging, and it's not in dispute that she did not have any medical credentials. But again, she was required to provide, albeit rather basic, healthcare. She was required by statute and by rule as the administrator and licensee designee of an adult foster care facility. She was required to provide basic healthcare to the residents of the facility she was running, which included administering medications as prescribed, monitoring a diabetic resident's blood sugar to just make sure that they were getting insulin as needed, and also to report a change in the resident's condition or make sure that the resident got additional care to address the change in condition. So she clearly was providing healthcare in fact, and by any plain meaning or dictionary definition of a healthcare provider, she was a healthcare provider. And frankly, to any other result, frankly, could not have been intended by the legislature and would frankly be absurd because, again, she was doing what she was supposed to be doing. She was supposed to be providing basic healthcare, so she was a healthcare provider. Finally, as to count 4, Your Honor, the allegation, of course, is that she interfered with an investigation. We do know that the investigation was pursuant to the Adult Foster Care Licensing Act, as Mr. Messer testified. She was a licensee or a caregiver or other person with authority over a vulnerable adult, and she intentionally lied to Lara about the medications that whether or not Ms. Harris received medication, specifically Lantus insulin. She stated that she told Lara that Ms. Harris had received that medication, that according to every other witness who was interviewed, and basically according to her own admissions to the state police later on, that didn't happen. So she obstructed that investigation by providing Lara with false information. Fortunately, Lara saw through that and found the violation, based on the failure to administer the Lantus insulin was established regardless, but she clearly obstructed the investigation by providing them with false information on that fact point. So again, Your Honor, the people moved for bind over. We've shown probable cause as to all the elements of all the charged offenses in the complaint, and we've shown probable cause that the defendant is the person who committed those offenses or was responsible for their commission. Thank you, Your Honor.
So in regards to counts number 2 and 3, they're the same allegation or same charge. So what differentiates the two?
So it's basically any false information that's placed in a medical record. Allison Schulten testified she didn't place her initials in the medical record as having administered Lantus insulin. Likewise, Valerie Glendenning, her initials were in there. She said she didn't do it. The edited MedPass results sheet indicates that that's also a falsified medical record. I mean, probably could have charged more counts of this, but there's numerous instances where she put false information in the chart.
Okay. And then in regards to healthcare provider, I know the public health code, in particular 333-26263 defines what a healthcare provider is as somebody who's licensed or registered. They're here, person who is licensed or registered or otherwise authorized under Article 15 of the Public Health Code to provide healthcare in the ordinary course of business or practice. Does Pleasant Lake Lodge meet that definition where they're not licensed under the public health code?
It does not meet that specific definition, Your Honor.
Okay. All right. But your theory is it meets it because it's administering medication, daily health care for its residents.
She was required to provide healthcare, not brain surgery, not, anything terribly sophisticated, but all the same basic healthcare. She was required to provide that. And therefore she was a healthcare provider under any ordinary common sense or dictionary definition of that term. I can't believe
We all
that.
know the law and common sense don't go hand in hand. So that's why I'm asking. So.
However, I can't believe the legislature would say that it was, I think this was frankly just a blind spot or that the legislature did not anticipate. I can't imagine that the legislature would deem it less culpable for someone in her position to falsify medical records than say, a nurse. That just doesn't make any sense. I think it's permissible in this instance to read the term healthcare provider in 750.492A to, it just includes someone who clearly is providing healthcare. It makes sense to do so.
Thank you. Defense?
I'll start with counts 2 and 3, Your Honor.
Okay.
And the court did find the one definition of healthcare provider in the public health code, which clearly states, paragraph E, healthcare provider means a person who is licensed or registered or otherwise authorized under the public health code. It is unequivocal and not disputed that Christie is not licensed under the public health code. So the plain dictionary definition of the statute that the legislature clearly drafted excludes her as a healthcare provider, but then it goes on further. Healthcare provider means a person who's licensed or registered under the public health code to provide healthcare in the ordinary course of business or practice of a health profession. That does not apply to Christie Tucker. Healthcare provider does not include a person who provides healthcare solely through the sale or dispensing of drugs or medical devices, and then there's a series of licensed occupations. None of those apply. Our law clearly identifies Christie Tucker as not a healthcare provider. And to the extent that it's not consistent, the statute that the prosecution has charged for those two, counts 2 and 3, MCL 750.492A, differentiates healthcare and non-healthcare providers, and I have a copy of the statute. So a healthcare provider who recklessly violates this subsection is guilty of a misdemeanor, punishable by imprisonment for not more than 1 year or a fine of more than 1,000 or both. Paragraph C, a person other than a healthcare provider who intentionally or willfully violates the subsection is guilty of a misdemeanor, not the felonies that have been charged. And I can tender to the court a copy of the
I have a
statute.
copy of it. I have a copy right in front of me.
So, Your Honor,
750.492A, you said, correct?
Correct, Your Honor.
Yeah, okay.
So as to counts 2 and 3, if the court believes that there is probable cause that the actions themselves occurred, I would say as a matter of law, clearly defined statutory law, that she is not a healthcare provider, which means counts 2 and 3 would rightly be misdemeanor versions of the felonies that the prosecution has charged. As to count 1, involuntary manslaughter, and I'm fully aware of the relatively low bar that needs to be met for a probable cause determination. I'm also aware that questions of fact are best left to a jury, Your Honor. So I'm just going to make a record of some things that I believed were quite clear from the prelim in its 2 days. I think there are serious concerns with Dr. Wagner's woefully inadequate half-hour review of, by his own testimony, of thousands of pages of medical records that warranted him with her diagnoses and her healthcare conditions and the condition that she was in prior to being discharged by Munson, that warranted a much more diligent review before landing on the first choice to a diabetic specialist. If you're a hammer, everything looks like a nail, and he landed on diabetic ketoacidosis without any consideration for the fact that we're dealing with, and her death is a tragedy, and it should not have happened. All right, I want to start with that. But this was a morbidly obese woman with extremely serious health conditions. At the time of her discharge, her A1C was a 10.1. Dr. Wagner said that was a dangerously high number, yet she was still discharged. This is a Medicare patient, a Medicaid patient. She should not have been discharged from the hospital in the condition. She hadn't passed any urine for at least the 2 days prior to her release. We don't know the condition. We don't know if it was an irreversible course by the time she was even discharged from the hospital, but this is what's known as a Medicaid dump. When the hospital, Munson Hospital, is not getting any money from this patient and they want her out. And that was, I'm sure that was part of the discussions with Ms. Harris's daughter. And for whatever reason, a nursing care facility with qualified trained medical professionals, if she was going to be discharged at all, she should have been discharged to a facility that had the capacity and the capability to give her the medical treatment that she absolutely required. All of those actions, Your Honor, occurred without any knowledge or action on the part of Christy Tucker. And we don't know what actual condition she was in at the time of her release. She had diagnosed coronary artery disease, carotid stenosis, high cholesterol, high blood pressure, peripheral artery disease, tachycardia, her weight. Dr. Wagner acknowledged that he considered no differential diagnoses, which is standard medical practice. And with somebody that had all of the precursors for a heart attack or a stroke, to not even consider them and rule them out. I think there's serious questions about the validity that the court should give that cause and manner of death as indicated in the medical examiner's report. I think there's a legitimate concern there for the validity. In terms of gross negligence, I couldn't help but note that the prosecutor kept referring to the plural, they, the facility. They didn't do this. They didn't do that. It screams of vicarious liability where, well, the buck stops with Christy Tucker, so she's on the hook for every bad practice, every non-action by her staff members, which she hired to manage the facility when she wasn't there. Most of the concerning medical degradation in her condition occurred during the 2 days when she wasn't working. So what does an employer do? He or she has staff members that are in charge of the place in her absence. That's exactly what they had with Amber Harris. Lantus did come in the list of medications. The physical Lantus did accompany Miss Harris when she was admitted to Pleasant Lake Lodge. It was on the med list. Once Christy found out that the medications were not entered, she engaged in the text messages with Amber Harris. Amber Harris says, well, no, I'm looking, in response to, are you looking at the med list? She says, no, I'm looking at the bottles. That would be the physical medication. So a common sense interpretation of that text message was somebody that I think communicates often with text with Christy. When she said they're in, and she said she looked at the physical medications themselves, what would be the logical assumption by Ms. Harris? that the Lantis was in the Quickmar system. So what's the significance there? Well, the Quickmar system will give an alarm indication if the medication's not administered. So on the days that Christy is off, going by therein, in terms of the clear text message from Amber Harris, she would have assumed that the Lantis was being administered that week. The insulin not listed in the MAR, it turns out that it was not, because only 2 of the medications on the med list were entered by Amber Harris. I would say that that's, and the fact that Amber Harris did not take any steps as manager of the facility in the absence of Christie's presence there. She took no steps to get medical attention. The only thing she did on day 1 or day 2 was, oh, give her some water. But then when she was vomiting and all these other health concerns are manifesting themselves, how would Miss Tucker know what was happening with any of the residents at her facility while she's off if her managers, the people that she's paid to run the place in her absence, aren't contacting her? Is that negligence on her part? Miss Tucker, the moment she saw that the quick acting sliding scale insulin aspart was not, that prescription was not filled, she did her due diligence at the very onset of this by contacting the pharmacy. Oh, well, it's in a third party's, it's got a third party signature on the prescription, so we can't fill this. So then there was communication with the hospital. This is the steps that she's taking to fill that prescription that the hospital deemed okay to release her without that prescription in hand when she left the hospital. That's not negligence on the part of Miss Tucker. She arrived at the facility that was woefully inadequate for the serious health concerns that Miss Harris had. She was already severely ill. But the prosecution is trying to put that this was a cascading effect of inaction on the part of staff members, independent of Miss Tucker, decisions by the hospital that preceded Miss Tucker's contact at all with Miss Harris, negligence on the part of Amber Harris, which I don't think there's any way to look at it as anything other than that. And ironically, she's the one that was at least a driving force for this prosecution and the investigation that happened a year and a half later. The criminal law, this could be a civil case where vicarious liability comes into play. Vicarious liability applies with the LARA investigation because that's for licensure. The prosecution is trying to lump all of the errors and lack of best practices that accumulated in the tragic result of this death, trying to place it all on Miss Tucker's shoulders. Your Honor, I was a prosecutor for over 20 years. And this screams of square peg, round hole type of prosecution. I am not going to comment on the bind over as to counts 2 through 4. This is not a manslaughter case. This is just a series of mistakes made by people beyond Miss Tucker. She does not deserve bind over on a charge of involuntary manslaughter, Your Honor. Thank you.
Rebuttal?
Thank you, Your Honor. I'll try to be brief. The facts that counsel overlooking, Judge, everyone who worked there, who was working there at the time, testified that none of them knew that there was that Kelly Harris needed insulin or that there was insulin on site to give to her. Valerie Glendenning said that when she went to Amber Harris and told her that Kelly's blood sugar was high, as Mr. Favor mentioned, Amber told her to give Kelly some water. Now, if Amber knew there was insulin in the building to give to her, wouldn't she have said, well, give her insulin? She didn't say that because she didn't know that. The only person who knew that there was insulin in the building or that Ms. Harris even needed insulin was the defendant, and that's why the defendant is charged with involuntary manslaughter, on top of the fact that she was the one responsible for what went on in that facility. So that's why it falls on her. Nobody else knew that Kelly Harris needed insulin or that there was insulin available to give to her. And furthermore, all those folks testified that the defendant knew that Kelly Harris got sick on the 4th day that she was there, that the defendant was aware of that, and yet nobody did anything. As far as the cause of death, it certainly meets the probable cause standard for this hearing judge. She was in the hospital because her blood sugar was high, that her diabetes was poorly controlled. The defendant made an ill-advised decision to accept her as a resident because she knew she was going to get paid having her as a resident. But then, as I said, basically did nothing to care for her diabetes. Didn't make sure that the insulin was in the MAR. Everybody said it was not there. Didn't respond when she got sick. Obviously, there was not an autopsy. That's not in dispute. However, Dr. Wagner is a very experienced physician, and he did indicate that he had considered other causes like a cardiovascular event of some kind, and that if he was satisfied based on the tests that were run in the hospital, that was not a likely cause of death, and that everything pointed in his 30+ years of experience to diabetic ketoacidosis, which of course was bolstered by the fact that her blood sugar was high almost the entire time she was there, as indicated by her glucometer. Thank you, Your Honor.
Thank you. Council, what I'm going to do is I'm going to take the matter under advisement because I want the opportunity to actually review and see if there's any type of case law that interprets whether a healthcare provider would apply in a case like this. I know what the definition says, but I want to see whether the statutes cross over. You're more than welcome to brief the issue if you want. We'll see if we can get back on within 2 weeks. We should be able to get, permitting your schedule's work, I will get this back on within 2 weeks. If it's easier to appear by Zoom, I'm going to allow everybody to appear by Zoom, so that'll help. And the only issue that I'm looking at right now is whether a healthcare provider meets the requirement of the definition of what Ms. Fleischfresher is.
Judge, I mean, I can tell you to be perfectly candid with the court, there is no case law or statute that says that a person in her position is a healthcare provider. However, I still think that, I mean, she literally was providing healthcare, ergo she's a healthcare provider, and certainly the legislature did not intend for something like this to fall through the cracks. Her falsifying a medical record is every bit as bad as a nurse falsifying a medical record, and it should be considered a felony.
So then what did the legislature mean by, and let me make sure I get the right language in front of me. And this is in 750-492A, a person other than a healthcare provider who intentionally and willfully violates the section is guilty of a misdemeanor. Who else would fall into that category?
I guess anybody who might have access to medical records who might have a reason to falsify them.
So at what?
A person who's not actually involved in providing healthcare to the person whose records those are.
But if she is the healthcare provider, because she's essentially the designee for Pleasant Lodge for Pleasant Lodge South. Who else would fall into that category? So for example, because she's the designee, if the front desk clerk then modifies the medical records, who's responsible?
Well, I would say that the front desk clerk is not in any way responsible for providing care to Ms. Harris. So then she would fall under the non-healthcare provider misdemeanor part of that statute. Again, the defendant, as the licensee designee, as the administrator, has a legal duty to provide healthcare, and which she is doing in most instances because she's required to do that. To say that she's not a healthcare provider under those circumstances is frankly is absurd. I realize it does not meet the statutory definition. I acknowledge that. But it just doesn't make any sense to say she's not a healthcare provider when she's clearly a healthcare provider.
Is there a distinction then in healthcare provider under the public health code versus what is contemplated under the act in which Pleasant Lake Lodge is licensed under?
So the public health, the section that's referred to in the definition that council cited is it 215, section 15? The part of the public health code, it refers to physicians, it refers to podiatrists, it refers to other types of therapists. I mean, people that are all have credentials, diplomas, et cetera, that make them licensed healthcare providers. And there's no dispute that the fact that the defendant did not have any such license. She's not a physician, she's not a nurse. We readily acknowledge all of that. And obviously, if a doctor falsifies a medical record, if a nurse falsifies a medical record, et cetera, anybody who's regulated, who's required to be licensed by the public health code, that would obviously be a felony. I'm just saying this is also a felony because she's still a healthcare provider.
So is a nursing, and I'm going to use broad terms, so bear with me. So is a nursing home, which I would consider a long care facility, is that licensed under a different act than what Pleasant Lake Lodge is?
Yeah, I mean, frankly, Judge, it's very convoluted. It's very confusing. I've been doing this for a decade and I still struggle to figure out some of this stuff. There's homes for the aged, there's adult foster cares, there's skilled nursing facilities. These are all regulated by different statutes. And,
And do any of those fall into the public health code?
I believe that skilled nursing facilities do, because everyone who works in a skilled nursing facility is a nurse or a nurse aide, or at least a medical assistant. Those people all have credentials. Some of these folks, like in adult foster cares, homes for the aged, assisted living facilities, they're called caregivers, which are what these folks are called, but they don't have any credentials. They don't have a license, but they're still providing care.
Okay, go ahead.
Healthcare provider means a person who is licensed or registered under the public health code. Ms. Tucker is not. Mr. Messer from Laura said that it's under the Adult Foster Care Licensing Act that gives her license. I asked about nursing homes, and Mr. Messer said they're licensed under the public health code. Completely consistent with, I mean, it's about as clear a definition as can be given. So, and then it goes on, healthcare provider does not include a person who provides healthcare solely through the dispensing of drugs. So
that would apply more to a pharmacist though, right?
Or any, so my 84-year-old mother-in-law, as of just a few months ago, is living with me. Okay, and that, for a variety of reasons, I mean, I could talk about that all day, but I assist her with her medications in terms of the timing. I am not a healthcare provider, but I administer medications and help her move up and down stairs and basic. So my home
you're
is
not licensed to do that. You're in a, I mean, I understand the argument you're making, but I mean, let's compare apples to apples here. I mean, you taking care of your mother-in-law is different than placing somebody in a licensed adult foster care facility. I mean, it just is. So
because hers is a business.
Business at different levels of care. but
I am providing medications. And from time to time, we have her medical records, and if I doctored them, there is a specific section of the statute that would make my crime a criminal offense, but it would be a misdemeanor. She is not a healthcare provider. If the court believes that a crime was committed on a probable cause basis, it's the misdemeanor version of counts 2 and 3 that are proper. Legally, in accordance with the statute, the plain as day statutory definition of healthcare provider.
good.
I was just gonna say that obviously in the situation, Mr. Favor's personal situation, he's not required to maintain medical records. This facility is required to maintain medical records, and they're also not allowed to falsify them. Frankly, Judge, I mean, I realize that we're in a gray area here. I think it's a gray area that the legislature did not intend. It was simply an oversight that for some reason adult foster care facilities were not included in this definition of what constitutes a healthcare provider. But at the same time, I just don't see how, they could have intended this to be merely a misdemeanor when if an LPN did it in a nursing home facility, it would be a felony. So, obviously we will, the law, I have researched this thoroughly. There really isn't anything beyond the statutes themselves for guidance. If the court chooses to interpret, I would mention that the definition that the council is referring to is not referenced in 750.492A. They're completely, one's the penal code and one's the public health code. I'm not saying that necessarily it wouldn't apply then, but it doesn't clearly apply. So if the court decides that the defendant's not a healthcare provider, we'll move forward with the misdemeanors. If the court accepts my argument that she clearly was a healthcare provider, albeit not meeting the definition in the public health code, then that issue can be litigated further down the road.
So, Mr. Faber, let me ask you, if Ms. Tucker Fleischfresher was someone who is licensed under the public health code, I assume an RN would fit that requirement. I don't know that, but for sake of argument, let's say they do. But she's not a practicing RN. She just has her license. And instead she's operating a business such as this, the AFC home, and she falsified the records. Would she then be subject to the felony just simply because she holds the registered nurse license?
I believe the answer is no, because she still doesn't meet the definition because she's not licensed under the public health code.
Well, but if she personally is, but let's say not acting in that capacity, so she's got a license for, let's say it's a physician, all right? Physician decides that they're going to open an AFC home, and in the capacity of operating the AFC home, which isn't licensed pursuant to the public health code, so it wouldn't meet the definition based on your argument of a healthcare provider, but yet it's a licensed physician who then modifies the health records, the medical records. How does it proceed then? Does it proceed as the misdemeanor or does it proceed as the felony? Because if we're looking at the licensure of the person.
Well, it was also clear from the testimony that Ms. Tucker did not do hands-on data. She was the administrator. She had employees that did the day-to-day contact with the residents and all of that. So I think it's a good academic discussion, but it does not apply to Ms. Tucker because she did not do the daily care at the facility. She managed the employees who did to various degrees of compliance with their job descriptions.
Okay. All right, the court, having heard the testimony, having heard the arguments and the like, we all know the standard today is a very low standard as opposed to the standard at trial of beyond reasonable doubt. The court does find in count number 1 in regards to involuntary manslaughter. I do find that the prosecution has met their burden in that case by acting as a result of a negligent omission, in particular that she was not receiving, Ms. Kelly Harris was not receiving her medically prescribed, her physician prescribed medication, sorry, in particular insulin, and that there was a legal duty to provide that. I do find that as the designee of the AFC home, she certainly had that legal duty to do so. In regards to count number 4, the vulnerable adult caregiving obstructing the investigations, I also do find that she, that Ms. Harris was a vulnerable adult. I believe she met that definition. It's clear that she could not live on her own and she needed the assistance. I also find that Ms. Tucker Fleischfresher obstructed the investigation that Laura performed in that regard by changing medical records. I believe in one of the exhibits, I believe it was People's 2, there was even instructions on how to participate in the investigation, only answering questions that were asked, etc. So I do find that the people have met their burden to count number 4. In regards to counts number 2 and 3, this is where it gets a little murky. And those of us in the profession know that while the legislature knows how to modify and write laws to make sure it encompasses everything that they intend it to do, they don't always necessarily do that. And while to the naked eye, it would seem that Ms. Tucker Fleischfresher is a healthcare provider, I think it's also clear that the legislature did not write the law as such. Whether it intended to, it was an oversight. I can only decide what the legislature actually wrote and not what its intent was when I have nothing in front of me interpreting intent. So as such, I do not find probable cause on counts 2 and 3. However, I do find that there would be probable cause for the misdemeanor offenses. And I can't put my hands on a statute right now, but as such, I will bind the defendant over on counts 1 and 4 as the 15-year felony in the 2-year high court, and counts 2 and 3 will be modified as the misdemeanors referenced by statute. Is there anything else for the record, counsel?
No, thank you, Your Honor. I don't know the court's practice, but because counts 2 and 3, I would say are relevant to the bound over counts, the defense would have no objection if those misdemeanors were added to the information in circuit court.
Yeah, so we make reference on the bind over that the information will be amended to the appropriate penalties on 2 and 3.
Thank you.
Okay, thank you. Ms. Fleischfresher, just a reminder that your bond conditions continue. Counsel, I have the original exhibit A for the defense. You may. And People's 1, I think, was actually left on the stand after we were done the other day. So, and then this is the court's copy of 2, so I'll hold on to that.
Okay. Thank you, Judge.
All right, thank you. Just a reminder, your bond conditions continue, and we are adjourned.